Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. If you're enjoying this legal content, please hit the subscribe button. For today's story, we are discussing a strange law in the state of Massachusetts that prohibits recording someone in public, even if they have no expectation of privacy, even if the person you're recording is a police officer. And someone has come to challenge that case. This is the case of Project Veritas versus Rachel Rollins. In this case, some various people want to record the police and other government officials as they're going out and about in their business. They don't want to interfere with their operations. They don't want to interfere with the police doing their business. They don't want to do it in a place of expectation of privacy. They'd like to record in public, in broad daylight. And the state of Massachusetts says you can't do that, which is pretty strange. They consider that to be illegal. So the United States Supreme Court, the Court of Appeals for the First Circuit has to determine whether or not this law from Massachusetts is in compliance with the First Amendment. Let's get started with this. Massachusetts, like other states, concerned about the threat to privacy that commercially available electronic eavesdropping devices pose, makes it a crime to record another person's words secretly and without consent. But unlike other concerned states, Massachusetts goes one step further. They don't recognize any exceptions to this based on whether or not the person has an expectation of privacy in what is recorded. As a result, Massachusetts makes it a crime for a civic-minded observer to use a smartphone to record from a safe distance what is being said during a police officer's mistreatment of a civilian in a city park, as it is for a revenge seeker to hide a tape recorder under a table at a private home to capture a conversation with an ex-spouse. The categorical and sweeping nature of this law gives rise to important questions under the First Amendment. So in pretty much every other state in the country, although I think there might be one other exception, perhaps Illinois, but I have to double check. But pretty much every state, they say, there's a whole bunch of stuff dealing with eavesdropping. So if you're listening onto a conversation you're not participating on, that would be eavesdropping. Wiretapping. So you're listening with a wire that people don't know is there. Recording in a place of expectation of privacy, so in someone else's home or in someone else's office or in someone else's car or somewhere else where a person might have an expectation of privacy. But Massachusetts goes that one step further. They're like, as long as you're recording it secretly and without permission, we don't care about expectation of privacy. So even if you're loudly having a conversation in the middle of a park, for example, then the state of Massachusetts says you can't record that unless they know you're doing it or you have permission. So yeah, merely recording with a smartphone, for example, would violate the law in Massachusetts, even though you're in a park in the middle of the day where no one has an expectation of privacy. Massachusetts is a little weird. And so the court notes that this is a weird result because it means that this person who's recording in the middle of the park in daylight as people are yelling is in the exact same position as someone trying to record surreptitiously in someone else's home. So it's like, yeah, first thing to note is this is kind of weird. It's a little bit out of step with the rest of this country. But hey, Massachusetts says this is what we want. Okay, let's read on. The first appeal we address today stems from a 2016 suit filed in the District of Massachusetts by two civil rights activists. They allege that the Massachusetts law violates the First Amendment insofar as it criminalizes secret, non-consensual audio recording of police officers discharging their official duties in public spaces, which is kind of weird. Massachusetts wants to make that illegal for some reason. The other appeal deals with Project Veritas. So this is two appeals rolled up into one. So we have Project Veritas, who wants to do some recordings of people in public or more people in public. And we have these other people who want to specifically record the police. So the court will consider these two propositions separately. The Massachusetts law defines a wire communication as any communication made in whole or part through the uses of a facility for the transmission of communication by the aid of a wire, cable, or other like connection between a point of origin and a point of reception. An oral communication is defined as speech, except such speech as is transmitted over public airwaves by radio or other similar device. So that would be, for example, just having a conversation in the middle of the park would qualify as an oral communication under the relevant law. The term interception, as defined in the law, is as follows: to secretly hear, secretly record, or aid another to secretly hear or secretly record the contents of any wire or oral communication through the use of any intercepting device by any person other than a person given prior authority by all parties to such communication. So yeah, Massachusetts law wrote it ruled really, really bigly or really broadly. So they say, well, an oral communication is one that, is just not transmitted through a wireless mechanism. So that would just be a conversation in public. That's an oral communication. And if you record that secretly or hear it secretly without the consent of all parties, that's a problem, even though you have no expectation of privacy. Massachusetts is a little weird. Roughly a decade after the law was enacted, the Court of Massachusetts construed the measure in a case, which concerned, among other things, whether audio recordings of a kidnapper's ransom calls had been made in violation of the law. In holding that they had been, the Court of Massachusetts agreed that even a recording of an audio of a person who had no reasonable expectation of privacy in what was recorded could fall under this prohibition. So this is just how broad and how absurd the results of Massachusetts is. So a decade after this law was passed, someone recorded the conversation of a kidnapper's ransom demands, and they did it secretly. They didn't tell the kidnapper their conversation was being recorded, because of course they weren't. So this wasn't a police officer. This was purportedly the person being extorted for money. So this random person decides to not tell the kidnapper their call is being recorded. And then the court says, yeah, that's a violation of the law. You didn't get the kidnapper's permission. You recorded it secretly. The kidnapping ransom call. You're in violation of the law. You get to go to jail too with the kidnapper. I don't know, man. Massachusetts didn't really seem to think this one all the way through. Or maybe they did and they just like it when everyone goes to jail or something. I don't know. Some years later, in a different case, the Court of Massachusetts held that the law did not implicitly exempt recordings of audio of persons who lacked an expectation of what was recorded. So whether you have an expectation of privacy or not is completely irrelevant as far as Massachusetts is concerned. In the case, the criminal defendant had been charged with violating the statute for having recorded the audio of his encounter with the police without the officer's knowledge during a routine traffic stop. So during a routine traffic stop, the person in the car decided to record the interaction with the police, and they didn't tell the police officer. So they intercepted that transmission without the permission of all the parties concerned, now didn't they? The defendant moved to dismiss the criminal complaint against him, so the driver of the car had a criminal warrant brought out for him, and he said, I want to dismiss. And the court said, no, because although he argued it didn't apply to the recordings of police officers performing official duties, the law didn't contain that exception, now did it? The Court of Massachusetts affirmed the denial of the motion by explaining that the statute is carefully worded and unambiguous, and it lists no exceptions for a private individual who secretly records the oral communications of public officials. So, yeah, no, if you record the police officer who's trying to detain you and you don't tell them you're recording it, that's a crime for which you can be charged in Massachusetts. How fun. The dissenting opinion in that particular case asserted that neither the text nor legislative history of the law indicated that the legislature had in mind the outlawing of a secret tape recording of a public exchange between a police officer and citizen. So the dissent, at least, is saying this isn't what the court meant. So we could have a potential originalist fight here. So the more strict textualists among us, including myself, would just apply the words on the page. So we'd be more in the majority. However, some people might look more to the intent behind it. So we could have an originalism fight. So this is like a Gorsuch versus Kavanaugh kind of thing over here. So this isn't actually involving Justice Gorsuch, by the way. Of course it's not, because it's a state Supreme Court. I'm just saying it's similar to their philosophies. So one would presume that Justice Gorsuch would have been in the majority of this opinion, and Justice Kavanaugh would have been in the minority of this opinion had it been decided by the U.S. Supreme Court, which it wasn't. But yeah, the straight textualists would say, well, that is what the text says, just applying the words on the page. And then the originalists, who believe a little bit more in the intent, will be like, that's not what they had in mind. So the dissent said, to support this narrower understanding of the measure, the dissent pointed out an example and said, here is what that would mean if that were true, just to prove it's absurd. And the example, of course, is continually relevant. So the example the dissent pointed out said that it claimed that under the majority's holding, that George Holliday would have been exposed to a criminal indictment rather than being lauded for exposing an injustice if the then recent recording of Rodney King's beating at the hands of the police officers in Los Angeles had instead taken place in Massachusetts. So this is some real good originalism fights over here. So the majority opinion in Massachusetts says, well, hey, this is just the straight text of the thing. It says, you need all permission. It doesn't contain any exemptions for anything. So, we're not going to look to anything behind it. The straight textualism, a little bit Justice Gorsuch philosophy, maybe. And the minority opinion may be a little bit more traditional originalist and saying, look, that can't be what they intended, despite the words behind the page. Because if we look to the original understanding or original public meaning, for example, besides the words, if that were really true, it would mean that had Rodney King occurred in Massachusetts, then this guy would have been arrested rather than lauded because he secretly recorded the police without getting consent of everyone involved. So therefore it would be illegal. And the majority opinion would say, yeah, that's illegal. If you have a complaint about it, go to the legislature. So yeah, we have some originalism fighting in the state court of Massachusetts. Okay, fun. The plaintiffs in this case allege that they are civil rights activists who regularly and openly record the audio of police officers without their consent as they discharge their official duties in public. Their complaint alleges that the plaintiffs would like to undertake the same type of recording secretly, but they fear to do so because of the criminal penalties. So they currently openly record the police so that they are aware of it. So that doesn't fall in the statute, but they also would like to do it secretly. And the reason they say they don't is because of this law. The plaintiffs in this case complain that they allege that others have been prosecuted for these recordings and that the police department's official training materials includes a training bulletin and training video distributed to the police that instructs officers that they may arrest and seek charges against private individuals who secretly record the police officers, even if they're performing their duties in the public. So the police are training on this and say, yeah, you can arrest those people. Based on the allegations of these plaintiffs, the complaint claims that the law, as applied to secretly recording of police officers engaged in their official duties in public places, violates the First Amendment by causing plaintiffs to refrain from constitutionally protected information gathering and from encouraging or aiding other individuals to secretly record police conduct in public. The district court then trained its attention on the level of First Amendment scrutiny that should apply to this ban. The district court concluded that the law in question was content neutral, which, probably is. It doesn't respect anything dealing with content. It's any communication, all communications. So it's a time, place, manner restriction. Okay, fair enough. So therefore, it should be not strict scrutiny. That makes sense. The district court then went on to subject the ban at issue to the lesser standard of intermediate scrutiny, which we use for time, place, manner restrictions, noting although the defendant had suggested that even a less demanding level scrutiny might apply, they had not developed this argument as to would be applied in this case. So the district court's going to apply intermediate scrutiny because this is content neutral, viewpoint neutral. It applies to all speech in all contexts at all times. You don't have to know anything about the content of the speech to know whether or not it is violating. So yeah, that's viewpoint neutral. Fair enough. Finally, therefore, the district court evaluated the ban on the intermediate scrutiny and determined that on its face, it could not survive that particular level of review due to the sweep. Despite recognizing that in this context, narrow tailoring does not require the law to be the least restrictive or least intrusive means of serving a government's interest, the district court explained the ban is not narrowly tailored to protect a significant government interest when applied to law enforcement officials discharging their duties in a public place. The district court noted that the law prohibits the recording even in circumstances which police officers would have no expectation of privacy of what's being recorded. So the district court at least said that this law cannot pass intermediate scrutiny because it is not narrowly tailored to whatever interest you're trying to protect, like the right to privacy, perhaps. Maybe that's what you're trying to protect. So what is the right that you're trying to protect behind this? Well, maybe your right to privacy or right to confidentiality. But they says, well, if that's your purpose, it isn't tailored to that because even if it's in broad daylight in the middle of public view, how could it possibly, what interest could you possibly have? And so it says it's not narrowly tailored to that. So that kind of makes sense. With respect to what the district court characterized as Project Veritas's as-applied challenge, which concerned the ban on secret, non-consensual audio recording of any person lacking a reasonable expectation of privacy in what was recorded, but not Section 99 as a whole. It also applied intermediate scrutiny. It then rejected this challenge on the merits because it concluded that the law's ban on such recording is narrowly tailored to serve the purpose of protecting privacy by permitting only non-secret recordings of private conversations, even though the statute bans secret recordings in circumstances where the private speaker might not have a reasonable expectation of privacy. So the two lawsuits, at least by the district court, are being treated differently. As it applies to the police, they say, yeah, you can record those. And with Project Veritas, they say, no, not to the public at large. That goes too far. So they're trying to split the difference between the police and the public as it relates to this statute, even though the logic of it is a little bit odd, because if there's no intermediate scrutiny for the police because there's nothing that would apply to their right to privacy, it also seems a little bit odd to treat it differently for the public. But that's what the district court tried to do, split the difference. For largely the same reasons that led the district court to grant summary judgment for the Martin plaintiffs on their interests relating to the police, it ruled that Project Veritas' challenge to the statute, insofar as it applied to secret, non-consensual audio recordings of any government official discharging their duty in public, was meritorious. Just like the ban on secretly recording of police officers without their consent when they're carrying out their official duties in public places, the district court determined a ban on recording of government officials more generally was also subject to intermediate scrutiny and was not narrowly tailored to serve a governmental interest. So, at least as far as the district court is concerned, they kind of gave Project Veritas part of what they wanted. So Project Veritas wanted it for any member of the public, and the other plaintiffs only wanted it for the police. So as to the police, they said yes. And then as Project Veritas, they said, well, if we're going to say it for the police, we can say it for any government official, but we won't say it for any member of the public at large. So the district court said, yeah, you can record the police and therefore any government official, but not necessarily any member of the general public, even if they're in a place that doesn't have an expectation of privacy. So that's what the district court said. Starting with fitness on the merits, we discern no problematic uncertainty as to the category of public officials to whom the plaintiffs wish to record. Nor does the district attorney suggest that the group of public officials encompassed by the phrase police officer is defined in terms that are too uncertain to permit court review. So we can figure out what we're talking about when we're talking about police officers. The concern that public spaces is too amorphous a category is mitigated here by the fact that we use the same phrase in prior cases to describe geographical bounds of a citizen's right to record police officers that we have recognized. Our cases have fleshed out the contours of the category of what it means to be in public by specifying that it includes traditional public forums, such as public parks like a Boston Commons, or the site of a traffic stop, and other inescapably public places. So the term public spaces is not too broad for our purposes. We know what we're talking about. The Martin plaintiffs seek protection for secretly recording rather than open recording. So that makes their challenge different from the one that we considered in a prior case. So they want the protection for secrets as well as open. So previously we said open where it's obvious, that's fine. But now we have to do secret recordings. That feature of this challenge, however, does not create uncertainty as to whether the law creates a risk that the plaintiffs will be prosecuted. So the fact that they want that difference is not a problem because we know these prosecutions occur because they have in fact occurred in the past. The Martin plaintiffs challenge a restriction on their right to collect information rather than on their right to publish the information that's been lawfully collected. But the First Amendment does limit government's regulation of information collection. So the First Amendment does limit what the government can do when it regards information publication. So the ability to record it and the ability to publish it at least might, in theory, be considered differently. As we've explained in a prior case, the First Amendment's protection encompass a range of conduct related to the gathering and dissemination of information. Based on all these observations, our prior case has held the following. It ruled that the federal constitutional guarantee of freedom of speech protects the right to record government officials, including law enforcement officers, in the discharge of their duties in a public space. And please take note here, this does not allow you to interfere with those operations. So you have the ability to record them, not interfere with them. So, before you try to do something and disrupt the police, not so much. And the police can also reasonably regulate this. So if, for example, they're trying to do something and they need you to back off, to give them space, they can do that too. So before you go completely hog wild, remember, you're supposed to be passive, non-participant in this equation. If you're a participant or close enough to be disruptive, that's a wholly different problem. The logic of the prior cases relied on the setting forth that encompassed description of First Amendment protected recording of police supplies, strong support for understanding it to encompass recording even if that recording is done secretly, at least as far as this particular statute uses the term. By the term secretly in this statute, we don't mean in a place of expectation privacy. We mean in broad freaking daylight. So to understand why that's true, one need only to consider the example of the recording of the beating of Rodney King. Like many recordings of police misconduct that have followed, the recording in the King case was made from a location unlikely to permit it to qualify as a recording conducted in plain sight of those recorded because, it was far enough away that police probably didn't know what was happening at the time, nor could they have reasonably come to that conclusion, right? But as recent events around the nation vividly illustrate, such undetected recording can itself serve a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Who will watch the watchmen? The answer is the public will. So this is interfering with the ability of the public to watch the watchmen. And that is within the public's rights, since the publics are the ultimate master of the Constitution at the end of the day. And not only aids in the undiscovering of the abuses of government, but also may have a salutary effect on the functioning of the government more generally. Maybe the government will work better if they know they're being watched. At least arguable, yes. In sum, a citizen's audio recording of on-duty police officers' treatment of civilians in public spaces while carrying out their official duties, even if that's conducted without the officer's knowledge, and probably especially if not, can constitute news gathering every bit as much as a credentialed reporter's after-the-fact efforts to ascertain what happened. The circumstances in which this recording could be conducted from distance or without the officer's knowledge and serve that very same interest, with all the accountability that provision of such information promotes, are too numerous to permit the conclusion that recording can be prohibited in all those situations. It's like, you're trying to sweep in a lot of stuff that would be very valuable. The First Amendment interest may be the most important interest because it's the thing that allows you to talk about the government. The government might prefer you not talking about them, but that's kind of exactly why you should be able to. So it's like you're trying to prevent people from recording what the government is doing and talking about it, government. It's like, that's kind of the very, very core of the First Amendment. The highest version of First Amendment is political speech. And this may be even a higher version still. Because not only is it political speech, it's speech specifically about the government conduct based on what they're doing. Kind of in the very heart of the First Amendment protection. It sweeps in a lot of conduct. We thus hold that the Martin plaintiff's proposed recording constitutes the type of news gathering that falls within the scope of the First Amendment, even though it's undertaken secretly. So you can record the police as they're undergoing their operations in public, but once again, do not interfere. That's a whole different set of problems. And now the court is going to point out what I've been trying to tell you for a little bit now. The government is under no obligation to permit a type of news gathering that would interfere with police officers' ability to do their job. The ability to record police is a very passive one. If you are trying to interfere or are interfering, even if you're not trying, you're going to have a bad time. Give the police enough space to do their job, please. Also, it's for your own safety. You probably really don't want to be right up in the middle of the action. That sounds like a dangerous thing to be. Maybe being back would be better. Okay, so you don't have to, the government doesn't have to let you interfere in their lawful business. That's true. But neither of the case law accepted the notion that the mere act of open recording, and the word mere here is doing a lot of work, the mere act of recording without more, so severely disrupts officers in carrying out their duties that justifies the restriction of such recording in the absence of consent. Mere act. If you're doing other things, you might have another time. Those cases, in respect at least, that the police's own view of whether recording of their work is desirable is not the measure. So whether or not the police would like it is not the issue. Whether or not we want it is not the issue. Whether or not it prevents us from doing our job, a little bit more so. Because whether it causes interference would be the relevant issue, not whether or not we like it. Okay, so we have dealt with the principal plaintiffs, the ones who want to record the police. And we have said, as to the police, there's a First Amendment interest in making sure the government is not, completely being horrible jerks. So we've dealt with the police issue. So now, having dealt with the police, we must turn our attention to Project Veritas, who wants to go further. Project Veritas wants two things. We want to record all government officials in the public, and we want to record all the public in the public on the fact that there's no expectation of privacy. So the court has to consider these two things. We've gotten it as to the police, and now the questions are, how about the rest of government officials, and how about the rest of everybody? All right, so let's turn our attention to that problem. There remains the question of whether the law's prohibition against recording is nevertheless properly calibrated to serve some other legitimate governmental purpose. That brings our attention to the challenges relating to Project Veritas's two more narrowly targeted attempts to show the law violates the First Amendment insofar as it bars the recordings. In the first of these attempts, Project Veritas contends the statute is unconstitutional insofar as it prohibits the secret, non-consensual audio recording of any person who does not have a reasonable expectation of privacy in what's recorded. In the second, Project Veritas contends the statute's inconstitutional insofar as it prohibits the secret, non-consensual audio recording of all government officials. So Project Veritas, as I said, is asking for two things. Project Veritas says we want the right to record everybody, and then also we want the right to record all government officials. All right, so let's consider those two requests from Project Veritas. We begin with Project Veritas's First Amendment challenge to the law insofar as it bars the secret recording of individuals who lack any reasonable expectation of privacy. So we want to record the public at large, at least if they don't have an expectation of privacy, which would be legal in pretty much every state, but Massachusetts maybe not. In response to questions from the district attorney, Project Veritas explains that it defines reasonable expectation of privacy as a circumstance in which the parties to the communication may reasonably expect the communication may not be overheard or recorded, which, is maybe not the most legally precise definition, but it's a fair one. If people in the communication would not expect it to be recorded or overheard. So this would at least potentially allow for a conversation in public to nevertheless have an expectation of privacy. So some people think any conversation in public doesn't have an expectation of privacy. And Project Veritas points out, and quite correctly, that argument goes too far. You can have a conversation in public that would nevertheless have an expectation of privacy. The question is the reasonable expectation of the parties. So are you doing it in such a way that it would be reasonable to think that people can't overhear you or record you? So by way of example, if you were having a relatively quiet conversation on a park bench, and if you looked around, you wouldn't see anybody there, right? Then that would be a reasonable expectation of privacy. The fact that someone might be listening from far away is not something that you could reasonably expect. So the question of you're having a conversation in the middle of a park bench. The questions might be, how loud are you having it? How many people are nearby? What is the reasonable expectation? So just because it's in public does not necessarily mean you don't have a right of privacy. And Project Veritas is making that argument, and quite correctly. That vague yet sweeping definition, I don't know how vague it is, but okay, is problematic from the perspective of ripeness. It fails to ensure the contours of the challenge are sharply defined. So the court is saying, well, that is so broad and so vague that we don't know what you're talking about. The court kind of does, but we're going to pretend that we don't because we don't want to deal with this right now. So we're going to say it's not ripe. Okay, the lack of precision also prompts concern that it's merely conjectural to anticipate that the statute will ever be applied in the many distinct contexts to which Project Veritas challenges the measure by the organization's own terms extends. So there's no reason to think that you'd be prosecuted for all the reasons you think you'd be prosecuted, even though there kind of is. But it's not ripe yet. Okay, let's go with that. It's so broad that you don't have ripeness. If the injury is not sufficiently close and narrowly and sufficiently present. All right. Accordingly, we conclude not merely that the challenge raises a ripeness concern, but that those concerns are so serious as to preclude the challenge from going forward. So as to Project Veritas, our friends over here on the First Circuit punt. As to Project Veritas, they punt. They don't say yes, they don't say no. They simply say, it's not ripe. In other words, you don't have standing. Everyone's favorite doctrine. It's not ripe because it's not sufficiently imminent. And it's so broad, we don't know what you're talking about, even though we do. But we're going to pretend that you don't. We don't. So, yeah, it's not ripe. Come back when you have something to actually complain about. Yeah. Okay. Well, that's fine, I guess. So we don't know if it's yes. We don't know if it's no. It's please ask us later. Thus, that brings us to the end of our current discussion of Project Veritas versus Rachel Rollins, the District Attorney for Suffolk County of Massachusetts. In this case, we discussed the recording of three different kinds of people: the police, other government officials, and the public at large, in situations in which they do not have a reasonable expectation of privacy. And in most states, this would not be a problem. But Massachusetts, for some reason, makes it super illegal. We're not sure why, but they do. And the Court of Appeals for the First Circuit says, look, when it comes to the police, they have a right to record the police, whether it's open or concealed. You don't have to tell them, and you can't interfere, but you have a right to record. It goes, whatever governmental interest you have, this is going way, way too far. And the public has an interest in figuring out what the government does. It goes to the core of the First Amendment protection. So as to the police, no problem. As to other government officials and the public at large, yeah, we're not going to answer that question right now because we don't want to. But, maybe come back and ask another day. The logic of the case would strongly suggest, in my humble opinion, that this would apply to at least other government officials, if not the public at large. But they're not going to answer that question right now. So we will have to wait for that answer for another day. At least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.